All right, we're gonna go back on the record on Brandon Bowman. Court is calling 2023 CR 6541, State of Texas versus Brandon Bowman. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Wendy McCullen for defense.
All right, and are you Mr. Bowman?
Yes, ma'am.
All right, Mr. Bowman, you previously entered a plea bargaining agreement with the state, and according to that previous plea bargaining agreement that was entered, it was for deferred adjudication. Now it's the court's understanding is that you no longer wish to receive the deferred adjudication. You're asking that you be assessed at 1 year in the state jail facility.
Yes, ma'am.
Why?
Because of the wait time for the program they're recommending. At first, when I entered the plea, it was just 3 years deferred, drug court, and some community service. I believe it was 120 hours. That I'm okay with. But if I'm gonna spend 8 months locked up anyways, you know what I mean? They have me in lockdown in here for something that I shouldn't even be in lockdown. I just have a previous charge that.
Well, that's why you're in lockdown.
No, well, I mean, okay, I understand that, but it's like I'm being punished for something that it's not like I'm fighting, it's not like, anything like that. But I'm in 23 hours a day lockdown, and I'm not trying to do another 4 months like that, just waiting for the program, and then I gotta go to the program for another 4 months. That's already 8 months. I might as well just do my state jail, and then I don't even have to worry about probation. But if you were willing to give me the probation with drug court and give me an opportunity to prove myself, I feel like putting me in a program, I haven't even messed up yet on probation. You already want to put me in a program. I mean, if I got an actual opportunity deferred, and I got 3 little girls, 4, 2, and 1, and I'm missing them talking, missing them walking.
Okay, let me ask you this. Why are you missing them talking and walking?
Because I messed up 2 years ago when I got this charge. I finally got picked up on the warrant, a year and a half later. And, I got kids now, I got a family that I'm trying to take care of, trying to be at home with. If y'all guys are gonna send me, I'm gonna spend 8 months of the program and then still have to do 3 years probation, that's crazy to me.
Yeah. Well, here's the thing. I'm reading his PSI report. There are so many things that are going on with him. And the fact that he has young children, which he probably shouldn't be around, that's concerning for the court. So he has previous mental health issues. He has all of this drug issues that we're here for. And
What drug issues, man?
I mean, that's what we're here for now.
I understand that, but I'm saying with what drug issues? Cause I said.
So you're just, for this, what they were going to give you probation for, you're just selling, not using, is that what you're telling the court?
No, I'm not saying that.
Okay.
Who said that?
Well, you said what drug issues, as though you don't know the reason you're here.
Well,
You're here on a drug case.
I understand that, but I'm not out there on multiple drugs, all drugged out all the time. I have a job, I work.
All right. I'm not gonna follow the 1 year state jail facility. So he can either accept the probation with conditions that I'm gonna accept, that I'm gonna set, or either you all can come back with something other than 1 year in the state jail facility. So those are the choices. I'm not accepting
I guess
the new plea bargaining agreement of 1 year in the state jail facility.
I guess it looks like I'm taking the probation.
I'm sorry?
I believe I'm taking the probation then.
Oh, no, that's up, whatever y'all want to consider, but I'm not accepting 1 year in the state jail facility. If you all want to do something other than the 1 year in the state jail facility, the court will of course consider it.
For a less than a gram charge.
We can have a minute to discuss.
Sure.
CPR for 15 minutes.
You ready?
We're ready when you are, Your Honor.
Okay. All right, we're back on the record. And 2023 CR 6541, Brandon Bauman. All right, so what have you all decided?
Your Honor, after much discussion with my client, he would like to try for the deferred adjudication and receive the treatments that the county is offering.
All right, anything else you wish to say on behalf of your client with regards to conditions?
No, Your Honor, I just do want to let you know that he has been in custody for 71 days. And he's really looking forward to getting in treatment, so he can go ahead and get that started.
And Ms. Abrams, on this case, was he considered for felony drug court? All right. All right, this is what the court is going to do. Court will sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person. The UA hotline until further notice. There's to be a referral to felony drug court. If he's not accepted, then they're asking for a evaluation for DDRF. But if he's not accepted into felony drug court, then next we'll consider lifetime recovery. And then if not accepted in that program, then we'll do the DDRF. And that's to take place while in custody. And he will not be released until he's accepted in one of those programs. If for any reason he's not accepted into either of those programs, then he's to come back to court. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the court will deem the community service hours satisfied. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Field visits 1 time per month until further notice. And the defendant is not to reside in any household with minors until further notice. And there's to be 120 sober meetings in 120 days. Probation, is there anything else?
No, sir.
Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, yeah.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful on probation in this court, communication is key. If there's an issue, you need to let probation know. If you feel as though they're not addressing that issue, you can always come back to court. And I'm sorry, one other thing, we'll have to do a gang evaluation. And there'll be a gang evaluation. I can tell you with that gang evaluation, you're probably not gonna be accepted into felony drug court.
Okay.
All righty.
When do these evaluations take place?
Felony drug court will probably be sometime next week. Lifetime recovery, probably in 2 weeks. DDRF, you'll have to ask probation.
Lifetime, what would make me not qualify for lifetime?
You have
And you're
gang
talking about,
affiliation.
and you're talking about inpatient?
Yes.
Okay.
You have gang affiliation. That's the
I'm not
problem.
even a gang member.
It's listed as Peckerwood on your,
I'm not active though.
all right, well, usually the way they label you as a gang member, once you're labeled as a gang member, you're a gang member. And according to the PSI report, it says current affiliation. It doesn't say past affiliation. All right, good luck to you. Who is here on Thomas Navarro? Oh, and guys, I'm sorry, the people who are behind the court reporter, if y'all can move to the other end. Court is calling 2023 CR 0056, State of Texas versus Thomas Navarro. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
William Davidson.
Are you Mr. Navarro?
Sir.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Navarro, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
No, Your Honor, we waived count one, proceed on count two with the enhancement program.
Any objection?
No objections.
Did you review the document entitled Court Admonishments and Defendant Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand and count two, you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams. If the state is able to prove the repeat offender enhancement allegation, your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes.
Mr. Navarro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, state is proceeding on count 2. You'd agree that you've been previously convicted of 1 or more felonies for enhancement. Punishment is to be assessed at a cap of 10 years in the prison. There's a $1,000 fine. State is opposed to your application. They're taking in consideration night mag numbers 762184 and 762186. There's to be restitution, if any, to the complainants and night mag number 762184. That includes Circle K at 5100 Crestway in Windcrest, Texas, 78239. Jennifer Green, Michael Shannon, Luis Molina, Amanda Aldana, William Blue, and Christopher Johnson. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Right.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is asking that you have no contact with the complainants that are listed in NIMAC number 762184. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
To count two, how do you plead? Guilty, not guilty, or no contest? To the enhancement paragraph, how do you plead? True or not true?
That has-
True. State, any evidence?
Yes, Your Honor, state exhibit number 112.
No objections.
All right. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. All right, counsel, are you asking for a PSI or are you okay with the court proceeding with criminal history from the state and any other evidence that you wish to present?
Yes, Your Honor, providing I have some time to get my witnesses. So.
All right, do you want to set it on the same date as your other case?
Yes, Your Honor.
All right, and let me see, what date did we give that? Was it June? June when?
11th.
Yes. All right, so we'll come back on June 11th.
Thank you.
All right, thank you.
My daughter,
That's fun.
my baby, for my witness.
That's nice.
Yes, she's gonna be an empty nester,
Wow.
like all in one fell swoop.
It's
All of this.
it's awesome.
Yeah. The house is very quiet and yeah, it's exciting. We like her. We like her.
Hello, Mr. Wortha.
I don't know what
How are you doing today?
you're doing.
All right, so here's the thing, when you're brought over, and mind you, I'm not taking anything as true, I'm just putting you on notice.
Yes, ma'am.
One, you can't be taking pens.
No, ma'am.
All right, number two, you can't be destroying stuff over there.
Yes, ma'am.
You understand?
Yes, ma'am.
So when you're brought over, you just need to sit in your seat. Don't touch any of the equipment because that equipment, though outdated, is still expensive.
Yes, ma'am.
All right?
I understand.
So this is what's going to happen with your case. My understanding from your attorney is that you want to have a contested hearing. So what will end up happening is the witness that they're going to call, because both parties have told me there's only one allegation in the motion. And that allegation in the motion is that you did not participate in an evaluation.
Yes, ma'am.
So somebody's going to be brought over to testify, and they're either going to say you participated in an evaluation, or either they're going to say you didn't.
Yes, ma'am.
All right?
Yes, ma'am. The only thing was I saw 2 different people for that. That's why I didn't know. The first one I saw, it was for the same evaluation.
All right. So here's the thing. What you believe the facts of your case
Yes,
to
ma'am.
be,
Yes, ma'am.
your attorney may not want you to discuss them
understand.
with me. So what I can tell you is, according to the allegations in the motion, they are saying, and I don't take any of it as true because they'll present witnesses. They're saying that you didn't participate in the mental health initiative evaluation in custody. That's it.
Yes, ma'am.
That's what they're saying you didn't do. So they're going to bring in a witness, and that witness is either going to say you participated in it or you didn't.
Yes, ma'am.
That's where we are. So your attorney tells me that you want somebody to be brought in to testify whether you participated in it or not.
Yes.
All right, so that's what we'll do. And that person is going to be by Zoom. It's going to be somebody, both parties have told the court, it's going to be somebody with Center for Healthcare Services. So that person who is alleged to have went to try to interview you is going to come and testify by Zoom. And either they're going to say, oh yeah, I recognized him. He participated in the interview, or either they're gonna say, yeah, I recognize him and he wouldn't participate. That's where we are. So we will come back. We're gonna come back in June. And that is going to be Miss Ferguson. Can we do this the week of June 17th? Is that enough time? Say, defense, are you available the week of June 17th?
I'm double checking, Judge, because I have 2 murder trials next month. It looks like the 17th is good. My murder doesn't start until the next Monday.
All right. So Miss Ferguson, we're having a hearing, contested hearing, should be relatively short. Mhm. All right, so we'll come back on June 17th. But before we do that, I'll go ahead and accept your plea. So that'll be one less thing we'll have to do on that date. All right,
Will that be at 9 on the 17th?
yes. All right, court is calling. That's one moment. 2022 CR 6940, State of Texas versus Bernardo C. Huerta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Meredith Chacon for Mr. Huerta, Your Honor.
And are you Bernardo C. Huerta?
Yes,
Are you the same Bernardo C. Huerta who was placed on community supervision in 2022 CR 6940 for the offense of robbery on July 18, 2023 for a term of 8 years? Is that you?
yes,
State?
Violated condition number 39 on or about the 30th day of April 2024 in Bexar County, Texas. The defendant, Bernardo C. Huerta, did then and there fail to participate in the mental health initiative evaluation in custody and comply with all rules, regulations, and instructions as directed by the court and or supervision officer in violation of condition number 39.
How do you plead to that? True or not true?
true.
All right, so if y'all want to go back and discuss things.
Okay,
All
Thank
right,
you, Judge.
thank you. You're welcome.
you want back there?
Go back on the record and 2022 CR 6940. All right, Mr. Huerta, it's the court's understanding you've had time to speak to your attorney
Yes,
in regards to your plea of truth.
yes, sir.
All right, do you still wish to plead true to violation of condition number 39 after speaking to counsel?
Yes, sir.
All right, did you understand by pleading true to violation of condition number 39, court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, Your Honor.
All right, the court will find violation of condition number 39 true. Is there a proposed agreement or no?
No, there is not, Your Honor.
All right, state, what are you requesting?
We're asking that you follow probation's recommendation, Judge, which is to alter and amend conditions for DDRF and to hold the probationer, hold Mr. Huerta in custody until the Center for Healthcare Services, the Tacoma evaluation, the TCOOMMI evaluation for DDRF is completed, Your Honor.
All right, defense, what are you requesting?
Judge, my client has been in since January awaiting the DDRF. The wait is very, very long for DDRF. There was, yes, he's pled true to not doing the eval. He did a part of an evaluation and thought he had completed the entire thing. But he would like the opportunity to do some sort of outpatient. Our understanding is the wait for DDRF is 6 or 7 months long potentially, which means he will be sitting in jail almost a year by the time that happens. And so is there anything, may I ask him if there's anything else?
Sure, but I will tell you, if you would have agreed to see them, you would have been done.
Yes.
And your 6 months would have been done.
Can I, whenever.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand, state your name for the record.
Bernardo, what's that?
All right. What
Yeah.
would you like to say?
Yes, sir. I do understand that, but it's still a 6 to 7 month wait. I have almost 2 years back time on this case already, just sitting in the jail.
Oh, do you just want to go to prison?
No, Your Honor, I don't.
All right, so here's the
But
thing.
I don't
Let's
ask
stop.
people-
No, stop. Let me explain something to you for a moment. Let's go off the record for a second. I don't know why people commit offenses You plead to the offenses that you committed. You're placed on probation. You get a motion to revoke. The reason why you have the DDRF pending is because you were here for a motion to revoke a violation of condition number 4. Guess what? If you were not placed back here for a violation for your motion to revoke, you never would have been waiting for a mental health evaluation. What ends up happening is people are on probation. They're excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say? I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. It's sort of like when people say, I'm 1,000% sure that I'm clean. You know what that usually means? They're dirty. Anything anybody says that's beyond 100%, it's usually not true. So you came before me with that. You were placed on probation July. Then February 2024, you had a violation of condition number 4. And I remember you. You came before me. You were so happy to be continued and not be revoked. And now you come before me.
I haven't.
And here's the thing though.
I haven't got out of jail.
Here's
I've been in jail
the
this
thing.
whole time.
Here's the thing. But the reason why you're in jail is because of your actions.
Yes, Your Honor, I understand
And
that.
people will come before me, and let me just tell you what happens. Some people will come before me and they'll say, I don't belong to a gang. I don't do drugs. Or I pay child support. And I always ask people when they would say, I pay child support. What, you want a cookie? That's something you're supposed to do. Like, you're not supposed to be before me on motions to revoke because you're supposed to be doing what you're supposed to be doing. And whenever I give people conditions, or whenever probation recommends conditions for them, they want to write their own program. If you could write your own program, guess what? I wouldn't have a job. Defense attorneys wouldn't have a job. The state wouldn't have a job. It would be great. But you can't appear before the court and then decide that you're writing your own program and you deciding that you're not going to follow through and speak to the person. If you would have spoke to that person in April, your 6 months would have been done. You would have been either in DDRF or not. They would have transferred you. But you know what? You've been pushed back. You know why you've been pushed back? Because you did not want to do the other interview because you're like, I'm done. And I always tell people when you're on paper, and that's what this is a contract, you're on paper. Even if somebody tells you, we're coming here for an interview, and even if you've thought you've already done the interview, doesn't hurt you to go ahead and do the interview, then you can come to court and say, they came to me for an interview for a 3rd time and I had already done the interview. Then we can discuss that. But when you don't follow through on what you're supposed to do, guess what ends up happening? Everything falls and you get placed at the end of the line, because guess what? There's somebody there who's on probation, who had to be interviewed for mental health and DDRF. And guess what? They took your spot. That's where we are.
That's the only thing. I'm just seeing a lot of people coming back, a lot of time waiting for it.
Yeah. I mean, I make rulings and there's a reason why these rulings are made. Right? And then you're also on, I believe you're on gang supervision as well.
I'm not sure.
Is he on gang supervision?
Sorry about that.
Well, were you a previous gang member?
I used to be, yes.
All right, so he was on gang supervision. So I have somebody standing before me who is on gang supervision. You know, you're given probation, the state recommended community supervision. And then you're over here pulling stuff off or trying to pull stuff off. That's why you have the DDRF. Now, if you don't want to wait for DDRF, I can revoke you. You guys can talk over what time you want, and I'll do what I will with regards to time. And guess what? You'll go to prison, you'll do your time, you'll get out. Either you're going to act right and follow the rules and conditions of society, which don't pick up any new offenses, take care of your children, stay on the straight and narrow. If you don't, you'll probably end up being a habitual, and your minimum when you come back will be probably 25, or maybe it'll be as a repeater in which case your minimum will be 15, depending on the charges. So if you want to discuss with the state and your attorney about doing your time, then you can do your time. And legally, I have to give you credit for any time that you've been in custody towards your time. So if you want to talk to your attorney about that and talk to the state about that, I'm not saying if they want to, if they agree to revocation and they want to give you a specific amount of time, I'm not saying I'm following that, but I'll consider it. All right? So if you want to talk to your attorney about that, you can. So I'll let y'all talk about that and I'll do this plea. All right, are the parties ready on Israel Fuentes Gonzalez?
Yes, Your Honor.
Oh, just one second. Are you ready?
Yes, but I do have to put something on the record. Judge, just to confirm, Navarro is not for PSI or TAP.
No.
Okay, thank you.
All right. So you need to put something on the record?
Just at the beginning, I actually did ask.
Okay. All right. We'll do that and then we'll take yours up. All right. We're back on the record in 2022 CR 6940, State of Texas versus Bernardo Huerta. And Mr. Huerta, you're still under oath. All right. Defense?
Mr. Huerta, we talked over the break about whether or not you would agree to go to DDRF, and you've indicated that you do not want to do that, correct?
No, I'm trying to get an outpatient program.
Okay, and knowing that that's not an
Oh,
option,
just one second. I'm sorry. I don't know if the court reporter heard his answer.
can you repeat that?
I was trying to get an outpatient program. No,
That last part?
but if it's not possible.
All right. So you're trolling off. So my understanding, and correct me if I'm wrong, your answer to the defense counsel question is you're trying to get into outpatient treatment. Is that correct?
Yes, ma'am.
Oh, it's fine. He's just mumbling. And if you're not able to get into outpatient treatment, then what was the next thing you said?
Not figure out what happens.
All right.
Mr. Huerta, I explained to you the only options in front of you are DDRF, if you agree to it, or that we have a sentencing and the judge will determine how much time you receive. Do you understand that?
Yes,
And since outpatient is not an option, would you like to avail yourself of the opportunity to do DDRF? Or do you want to be sentenced today?
I guess we'll sentence.
Okay, and I advise you to go with DDRF, correct?
All right.
That's all I had to put on the record. Judge.
Thank you. All right. So he's pled true to violation of condition number 39. Is there a proposed agreement?
There's not, Your Honor. I would ask the court, I know that the defendant has stated that he would like to be sentenced. I don't think you should do that. I think you should say, hey, you're going to the inpatient. That's, I think that's a better option for him. If, I know he said he wants to be sentenced, but, and I can speak to that if the court would like to.
Sure. I mean, here's the question, Mr. Huerta. You don't get to decide whether you're in inpatient treatment or outpatient treatment. Now, they want to interview you for DDRF. Either you're going to do that or you're not going to do it. So, do you want to be interviewed for DDRF? Yes or no?
Yeah, I guess.
No, it's not I guess. It's either yes or no.
Yes.
You can't write your own program. Here are your options. Your options are you can be interviewed for DDRF. And if they deem that you're acceptable to the program, that's where you're going to be. Or if you don't want to do that and you tell the court you don't want to do that, then I will revoke you. Those are your two options. Now, if the court were to revoke you, then the most I could sentence you to is 8 years. I'm sure your attorney will ask for something probably less than 8.
20 years just to this deferred.
No, he's not on deferred. He's on regular.
Is New okay? Oh, okay.
Yes. So
I was on deferred also. Okay.
no, he's on regular. So the most I can sentence him to is 8 years. So, and he legally, I have to give you credit for any time served that you've been in custody. So those are your options. Do y'all need to discuss this again or no?
Do you want to do DDRF or do you want to be sentenced? That's not an option. The judge has told you, and I've told you, there's two options. Sentence, we don't know how much time, up to 8 years. Okay, to be,
All right. So you want to be sentenced?
Yes,
All right. You've pled true to violation of condition number 39. Court is finding violation of condition number 39 true. State, what are you asking for?
We're asking for the 8 years, Your Honor. The defendant has been to the prison in 2010 for an ag assault with a deadly weapon. I know you've seen the SIPs in this, and and I know it's a robbery, Judge, but it came in as an ag robbery. This was, defendant was stealing from an O'Reilly's, when the employee tried to stop him. He pulled a knife, on the plain witness in this case, Judge, so. This is an inherently, scary crime, Your Honor, and so that's why we're asking for the 8 years, Your Honor.
All right, defense?
The client would ask that you give him the minimum of 2 years and credit for time served.
The court is going to grant the motion. The court will sentence you to 8 years in the prison. The court will give you credit for any time served. There's to be, just one moment. There's to be no contact with Abel, Abel Ramos, and O'Reilly's, located at 955 South General McMullen, San Antonio, Texas 78237. And there is to be a $500 fine. Time and money will run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yeah.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegation in the motion, not the fact that you're on community supervision. Do you understand?
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay? Yahiri Ramo, come forward, please. Hello.
Hi.
Hi, are you employed?
Yes, I am.
All right, what is your work hours?
From 9 a.m. to 2 p.m.
Is that Monday through Friday?
Yeah.
That's yes.
Yes,
Okay. So when's your next off day?
I'd say Wednesday, Thursday.
All right. When you say Wednesday or Thursday, is that next Thursday or this Thursday?
This Thursday.
This
And
Thursday?
also next week on Wednesday and Thursday.
All right, so what we're gonna do, your attorney is asking that your case be recalled for Thursday of this week.
Mhm.
So you're not working this week, Thursday?
Tomorrow.
No, Thursday. Tomorrow is Wednesday. And the next day is Thursday, the 30th. Are you working on that day?
No.
All right, so your attorney is in Guadalupe County on a motion to suppress up there. So we'll bring you back on Thursday the 30th. So once you sign the reset form, you're excused, but make sure you just back to, on Thursday on time, all right?
Okay, that's fine.
All right, thank you. All right, so where are we on this case as far as discovery is concerned?
I think counsel would like to come into the office to review the forensics.
Okay,
And so I gave them our contact information and we're gonna make it happen.
all right.
That's right, Judge.
So is there any CPS records in this case or no?
Counsel, I'll have to defer to you, or this is a case with Ally. Have y'all had a chance to, is there anything? Cause I can take a look real quick. I don't know if anything comes to mind.
I don't think I have any yet, other than the obvious.
Well, is the
We've got two
complainant,
forensics. He has 2 shots they've been.
all right, so is the
Sure there
complainant,
is. I don't
and
have
the,
it yet.
all right, and the complainant in this case, and these are just allegations, I know, is this alleged to be,
There are 2 cases.
yes. So the complainant in the case, is it alleged to be a relative or someone that he's alleged to have been living with? Because that'll let me know if there are CPS records. Do we know? Is there any way to look to see?
I believe it's gonna be the granddaughter.
I think it's.
All right, so there should
I'm
be,
not sure about-
there will probably be CPS records then. So,
And I'm gonna reach out to them, even if Ally's already working on it.
okay.
Even if Ally's already working on it, I'll re-up on it today as well, while we're here.
All right, Ms. Ferguson, on Luis Martinez, give me a 45-day reset. All right, so we're going to come back on July 15th.
and state if all the discovery has been tendered, you'll need to be prepared to make an offer on that.
That sounds great, Judge. Thank you.
All right. Is there anything else?
Nothing further going.
All right, thank you.
Let me check real quick if they're.
Court is calling 2024 CR 3366, State of Texas versus Marie Therese Miles for the state.
Hank Wilkins for the state, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 2:40 p.m. Deputy, did you make an announcement for Marie Miles in the hallway?
Yes, Your Honor, I did.
And was anyone there?
No, ma'am.
All right, and the defendant has not appeared in court. State?
Your Honor, we're asking for a bond forfeiture.
All right, that will be granted. She'll be remanded without bond. If she makes an appearance, the court will reconsider. And one more.
Yes, ma'am.
Court is calling 2024 CR 3480, State of Texas versus Josue Alvarado Teche, Teche, for the state.
Hank Wilkins for the state, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 2:41 p.m. The defendant has not made an appearance in court. Deputy, did you make an announcement for the defendant?
Yes, Your Honor.
And what were the results?
No answer.
State?
Your Honor, we're asking for a bond forfeiture.
All right, that will be granted. The defendant will be remanded without bond. If he makes an appearance, the court will reconsider. Thank you.
Thank you.